Welcome to This Explainer. Today, we're diving into a story that honestly plays out way less like some dry, dusty corporate legal battle and a whole lot more like a high-stakes medical thriller. We're going to unpack a monumental case from the Supreme Court of India that completely changed how we look at those little bottles and boxes of medicine sitting right in our own cabinets. Because this isn't just about corporate logos or clever branding, we're talking about what happens when a simple mix-up literally threatens human life. Okay, let's dive right into this. I want you to focus on the two words we're looking at here. Seriously, go ahead and actually say them out loud wherever you are right now. Falci-tug and Falcitab. When you see them spelled out, sure, the endings are a bit different, but when you speak them, they have a terrifying phonetic similarity. And that exact similarity is the beating heart of one of the most educational and influential decisions ever handed down in Indian intellectual property law.
So, let's set the stage with Section 1, the problem. The malaria medicine mix-up.
Picture this. It's the year 2001. Two massive pharmaceutical giants, Cadila Health Care and Cadila Pharmaceuticals, find themselves locked in a huge dispute. Both of these companies had just rolled out life-saving anti-malarial drugs under the brand names we literally just practiced, Falcigo and Falcitab. Both medicines are meant to treat malaria, which, as we know, is a really serious, potentially fatal disease. Now, step out of the courtroom for a second and imagine the reality on the ground. Picture a busy, chaotic pharmacy. There's a line out the door, phones are ringing off the hook, people are talking over each other, a doctor calls in a prescription for a critically ill patient, or maybe someone hands over a really messy, hurriedly scribbled note. What happens if the pharmacist mishears Falcigo as Falcitab? Well, the consequences of that specific kind of mix-up are absolutely severe. In the pharmaceutical sector, we aren't talking about accidentally grabbing the wrong flavor of potato chips, right? If a doctor, a pharmacist, or the patient themselves confuses these two products, it leads to the incorrect treatment. It causes dangerously delayed recovery for a disease that requires immediate, hyper-accurate intervention. And worst case scenario, we're talking about the potential loss of human life. It is quite literally a public health crisis waiting to happen, all because two words sound just a little too alike over a crackly phone line. Which brings us to Section 2, the agitation. A matter of life. See, this wasn't just some petty squabble over market share. Cadila Health Care took this all the way to court, arguing that this phonetic similarity was a disaster waiting to happen. They pointed out that vulnerable patients, alongside the medical pros treating them, were put at an unacceptable level of risk because of how easily one medicine could be mistaken for the other. Now, to fully grasp what the courts had to evaluate here, we need to understand the core legal hurdle known as deceptive similarity. Basically, deceptive similarity happens when a trademark is so incredibly close to another that it's likely to confuse the public. And the kicker, it's not just about whether two boxes look identical on a pharmacy shelf. It's also about whether they are likely to get mixed up verbally when spoken out loud. Now, what's absolutely fascinating about the distinction we're looking at right now is exactly that point. It is not just about what you see. It's about how it sounds. Actually, think about it. Even if Cadila Pharmaceuticals designed a box that was a completely different color with a wildly different font, a verbal order over the phone could instantly blur Falcigo and Falcitab right together. The court recognized they had to look way beyond just the visual spelling. In the medical world, prescriptions are constantly being yelled out or mumbled over the phone between doctors, nurses, and pharmacists. Moving on to Section 3, the solution, the stricter pharmaceutical standard. Realizing the massive gravity of this issue, the Supreme Court of India stepped in and adopted a brilliantly consumer-centric approach. They essentially said, look, trademark law isn't solely here to protect corporate profit margins. It has a fundamental duty to safeguard public health and make sure consumers aren't misled. And the comparison here brilliantly illustrates the hard line they drew between ordinary consumer goods and life-saving medicines. Think about it. If you go to the store and accidentally buy a deceptively similar brand of soap, it's honestly just a funny mistake. You might hate the smell, but you're going to be completely fine. But making that same mistake while dispensing a pharmaceutical product, that can be a fatal error. The stakes are simply night and day. Because of those sky-high stakes, the court laid down a truly landmark principle. A lesser degree of proof of confusing similarity is required when we're talking about medicinal products. Basically, medicines demand a much, much stricter standard. Courts have to exercise extreme caution, which means they need way less evidence of confusion to step in and shut down a potentially dangerous pharmaceutical trademark. It's a proactive defense. Even a tiny, minor degree of confusion with medicine is disastrous. You absolutely do not wait for a patient to take the wrong pill. You stop the confusing pill from ever hitting the market in the first place. Let's look at Section 4, the impact. the deceptive similarity test. So how do we actually apply this super strict standard in the real world? Well, the Supreme Court didn't just rule on Falcigo versus Falcitab. They actually created a practical, comprehensive legal checklist for all future trademark cases. Let's walk through this evaluation test together. Courts now have to look at the nature of the marks and their visual appearance. Crucially, they absolutely must analyze the phonetic similarity, how they actually sound. They also check the class of purchasers, the mode of purchasing the goods, like is it ordered verbally, and all the surrounding circumstances. But here is the brilliant part. The court doesn't just look at these factors in a vacuum. They blend them together to view the product exactly how an ordinary, stressed-out consumer would. They ask, in the real world, under real pressure, could a normal person get these confused? That comprehensive verbal and phonetic analysis, it's now a mandatory safety check in India.
For modern businesses, this judgment is an incredible step-by-step lesson. Creating a distinctive brand name today isn't just some fun marketing exercise. It is a critical matter of public safety. Businesses absolutely must go beyond just a visual comparison. They have to include phonetic analysis, especially if their products might be ordered out loud. And it really highlights why comprehensive trademark clearance searches are totally non-negotiable before launching a brand. Actually, if you've ever wondered why modern drug names sound so incredibly bizarre or hard to pronounce with all those random X's and Z's, this multi-step check is a huge reason why. They literally have to be legally distinct from everything else on the market to prevent this exact kind of mix-up.
Which brings us to our final section. Section 5, the legacy, a promise of safety.
This 2001 decision didn't just make headlines and then fade away into the archives. No, it completely redefined the balance between protecting commercial goodwill and serving the larger public interest. If we look back over the last 2 decades, what happened in 2001 was a permanent, monumental shift. Cadila Health Care versus Cadila Pharmaceuticals remains one of the most frequently cited authorities in Indian trademark litigation. Its principles are still actively shaping judicial decisions every single day. It's an absolute must-know case for law students, trademark pros, and business owners. Today, it stands as a continuous, vital shield for consumer protection, especially in the super-sensitive pharmaceutical space.
The real, enduring significance of this judgment is perfectly captured by this quote from the source material. A trademark is more than a business asset. It is a promise of identity, trust, and safety. The court proved that when that promise is compromised, especially when we're talking about medicines, the law must and absolutely will intervene to protect the public. Consumer welfare has to prevail. So the biggest takeaway from this explainer is that the names on our medicines are heavily, heavily guarded for our own protection. I'm going to leave you with this final thought. Next time you pick up a prescription from a noisy, crowded pharmacy, will you look a little closer at the name on the box and recognize the invisible legal shield that's actively working to protect your life? Thanks so much for exploring this fascinating case with me, and I really hope it changes how you look at the